welcome to this final instalment of our Junior PI seminar series. And again, thank you all for joining us and for sticking around while we've got things moving. I'm joined today, my name's Connor, and I'm joined today by my colleague Dan. We're both practitioners here at St Philip's Chambers. We're going to talk today about the potentially thorny topic of Part 36, particularly with respect to the fixed costs regime. Just a reminder for everyone that we do have the Q&A function. Please do put your questions in there and I'll have a look at those at the end, time permitting, of course, but we'll try and include those for those that have them, obviously bearing in mind the tech issues. As I say, my name's Connor. I've got a practice that covers costs specifically, also personal injury, clinical negligence and employment as well. Dan.
Yeah, we'll keep the introduction short, but I cover PI, clinical negligence and regulatory work as well. It's good to see lots of you on the call this morning.
We've set out a bit of an agenda for the day there. We're hopefully going to give you a whistle-stop tour of the main tenets of fixed cost Part 36 offers and some practical tips as well. We aren't going to go into the meat of some of the cost-specific disputes today for the purposes of this relatively short talk, but of course we'll highlight some of the more common pitfalls as we work our way through things to just bear in mind. So what is a Part 36 offer? It seems relatively elementary, perhaps. It is a self-contained procedural code, of course, for making offers to settle. It's designed to encourage settlement and bring litigation to an early close. The fact that it's a self-contained procedural code is talked about an awful lot in costs litigation. It's something that distinguishes Part 36 from the other parts of the CPR, and so it operates sometimes slightly contrary to what we would expect, bearing in mind the rest of the CPR provisions. And that codifies a case called Flynn from 2004 in the Court of Appeal. It does have to be, essentially the idea is that it does have to be a genuine offer to settle, and it has various cost consequences which we'll cover, and indeed there are various rules about how that operates with a relevant period and so on. In terms of the relevant rules that we all need to bear in mind, there are essentially three sections to the new regime, and we are just going to talk about the new regime today for the purposes of this talk, post 1st of October 2023. Section 1 deals with general Part 36 offers. Section 2 is the one that is perhaps most relevant to all of us today in terms of the application of Part 36 to the fixed costs regimes. Of course, these, for PI purposes, are going to be where the cause of action accrued after the 1st of October 2023. And then indeed, Section 3 deals with the protocols and specifically while the case is operating within them, as opposed to when it has fallen out. I wanted to ask the question of what constitutes a valid Part 36 offer. And it seems very simple, but it's something that is very often fallen foul of. And we do need to be quite careful because, as I say, it's quite complex, and indeed it can be fallen foul of. I've set out Part 36 CPR 36.5 on the slide there, which sets out the procedural requirements for making a Part 36 offer, which include things like it has to be in writing and say it's a Part 36 offer, include the relevant period, and say whether it's the whole of the claim or a particular issue, and indeed whether it takes account counterclaim. I've also mentioned 36.18, which is of particular note to personal injury practitioners, in terms of including information about future pecuniary loss. The mandatory requirements generally must be followed. There is the possibility of the validation of formal or technical defects following a series of Court of Appeal judgments, the first of which was in 2011. But I wouldn't want to bank on that. Of course, it dramatically increases litigation risk in that regard. We've set out more of the peculiar elements of what can and can't constitute a valid Part 36 offer on the next slide here, which is, and I just want to highlight a couple of them. First of all, in my view, the parties are unlikely to be able to make a cost-bearing Part 36 offer while the claim is in the portal. And I'll clarify what I mean by that. That is making a separate Part 36 offer outside of the portal process, the protocol process. The protocol, Part 3 of CPR 36, sets out how the protocol works, and it disapplies Part 1 and 2. It then says that if we don't make an offer that's in the form of Part B of the court proceedings pack, it doesn't bear Part 36 consequences. So please just bear that in mind. It's something that I've seen once or twice, and it is certainly something that's worth considering. The second one that I want to highlight is offers for global sums inclusive of costs. I'm sure that Dan will agree with me on this, that we see global Calder Bank offers all the time. Please don't try to make a global Part 36 offer because it doesn't count, essentially. Finally, please do bear in mind that parties can contract out of fixed costs, particularly risky for defendants on this one. That applies to both old and new regimes. There's a bit of question for a time whether or not that was going to be the case, but it is now the case that it applies before and after 1st of October 2023. The overriding theme of all of this, and my one takeaway, is please use the form N242A. That is the Part 36 pro forma, and it's essentially a tick box exercise. It does ensure that the vast majority of these problems don't have to arise. Again, just another thorny issue that sprung to mind and that I wanted to talk about a little bit was liability only Part 36 offers. It's dealt with head on by a case called Mundy and Toohey, which I've set out there on the slide. It's from the High Court. I won't go into the meat of the facts because it's a detailed case in which several proposed Part 36 offers were made. The nub of the issue was a liability only Part 36 offer something that could be deemed to be beaten at trial and therefore for the consequences of Part 36 as a result? And the answer was no. The court found that liability couldn't be severed from the remainder of the claim in that case, and so it didn't constitute a separate issue, such that it would fall under the regime. So please do bear that in mind. There are exceptions, and I've set out one particular one on the slide there. If it's a split trial, then it is arguable that it's a separable issue because it's you're essentially going to court, you're having a hearing, particularly for those purposes. I am now going to hand over to Dan to take us through some of the next steps in terms of our Part 36 offers.
All right, so good morning again, everyone. Part 36.6, so looking at defendants' offers. So a Part 36 offer by a defendant to pay a sum of money in settlement of a claim must be an offer to pay a single sum of money. So we were just talking about offers on liability, for example, but clearly there's a consideration here that has to be borne in mind in light of that provision. We then have a defendant's offer that includes an offer to pay all or part of the sum at a later date than 14 days, has a particular effect under the regime. So following that date of acceptance will not be treated as a Part 36 offer unless the offeree accepts that offer. So there's considerations both sides of the table. If you're making a defendant's Part 36 offer and you're including an offer to pay all or part of the sum after a 14-day period, clearly that has some effect on your offer. And equally, on the other side of the table, if you're going to accept an offer that has that condition within it, then it's going to have different effects to the ordinary Part 36 regime. Then moving on and having a look at clarification of offers. So the offeree under 36.8, within 7 days of the Part 36 offer being made, can request clarification of the offer. And this is probably an underutilised provision. There are often offers that perhaps have been drafted very quickly, maybe without use of the form, and actually the wording is not particularly clear. And a clarification doesn't go in. There's then a mistake that is made in the sense that the parties misunderstand the agreement between them, and then that causes all sorts of satellite litigation down the road. So please use the opportunity to clarify the offer wherever possible.
I think you'll agree, Dan.
Yeah.
Particularly important where the offer isn't purely monetary. If it's not necessarily entirely in monetary terms, then there's obviously scope for argument later over whether or not a judgment is more or less advantageous than that offer. And so please do utilise the opportunity to clarify offers, pin the other party to precisely what it is that they are offering, so that you know whether or not to accept it, and indeed the court knows whether or not it's been beaten at a later date.
And if you don't get a clarification back, then there is a procedure for dealing with that. So if you don't receive a response within the 7 days of the request, then there is the option to essentially go to the court and get a response in that sense. If the court makes an order under paragraph 2, it can then specify the date when the Part 36 offer is to be treated as having been made. That's obviously important in terms of then determining the consequences beyond that point. And if you fail to seek clarification, then there may be later precluded from arguing that the offer contained insufficient information to be valid. So even more of a reason really to issue a clarification if there's any doubt at all about what the terms of the offer are. Then in terms of moving on to withdrawal and variation, so Part 36 offer remains open for acceptance. This, of course, when we all start as a lawyer, is one of the key differences with the Part 36 offer as opposed to some of the other regimes. Unless and until its terms provide for automatic expiry. That is sometimes an underutilised element of the process. It's always worth considering whether or not to put a provision in there for automatic expiry. And the other option is if it is withdrawn by the offerer. And of course, the effect of withdrawing a Part 36 offer is it then fails to have the appropriate consequences later on. Which can be a good thing in some circumstances and a not so good thing in others, so it needs careful consideration. Written notice of the withdrawal or variation does need to be served, and of course all the rules on service as usual apply to that. And after expiry of the relevant period, a Part 36 offer that has not been accepted may be varied without the court's permission, or may not be varied without the court's permission. Where a Part 36 offer is varied to make it more advantageous to the offeree, then it will obviously move on to have those effects. And as a new Part 36 offer with a new relevant period, will have that effect under 36.9 subsection 5. And if, of course, an offerer wishes to withdraw their Part 36 offer or vary it to something that's less advantageous, during the relevant period, then 36.10, as we've touched on, then has to be followed. So there are certainly plenty of considerations in and around that area to be considered. Then if we move on and we have a look at acceptance, so 36.11, so a Part 36 offer is accepted by serving written notice on the offeror. That's important. So there are sometimes issues that arise where the acceptance is maybe given orally and not given in writing, and that can cause issues down the line. So it's really important the regime specifies it must be written notice that is given. A Part 36 offer may be accepted at any time, whether or not the offeree has subsequently made a different offer. So there can be multiple offers sometimes floating around that effectively could be accepted. CPR 36.11, any time means any time in which the claim continues to subsist between the parties. And the case of Joyce deals with that point. And CPR 36.11 deals with situations in which the courts must give permission for acceptance. For example, permission is rarely given mid-trial, so you can't wait to see how the winds are blowing, I think is the phrase that's used in the case law, before accepting a Part 36 offer mid-trial. You are going to probably get stuck if that's your case strategy.
Interesting departure, as Dan was saying, that Part 36 has from contractual regimes is that a rejected offer can still be accepted later. It doesn't render the offer incapable of later acceptance unless it's withdrawn. So that's a really interesting point that I think Dan's raised there. And so do bear in mind, as I say, Part 36 is a self-contained procedural code. It operates within the CPR as opposed to as a contractual regime.
Yeah, so don't apply your contract rules. This is a procedural code, so it's self-contained in that sense. So keep it within the Part 36 rules. Cost consequences of acceptance. So under the general rule, if a Part 36 offer is accepted within the relevant period, and that is important as well, sometimes we get acceptances outside of the relevant period, and of course that does have effects under Part 36 that can differ from the norm. But if it's accepted within the relevant period, then the claimant will be entitled to the cost of the proceedings up to the date on which the notice of acceptance, of course in writing, was served to the offeror. And the expectations are clearly set out within the CPR as to what the effects will be. And then looking at fixed cost consequences of acceptance, because that's the focus of our talk today, is on the fixed cost elements associated with Part 36. It does apply to a claim in which Section 6, so fixed costs on the fast track, Section 7, fixed costs on the intermediate track, or Section 8, which is the noise-induced hearing loss, where Part 45 applies. Fixed costs will be calculated by reference to the amount of the Part 36 offer which is accepted. So that's important that it is the amount that's accepted that is the key figure. And the parties are entitled to the disbursements allowed in accordance with CPR 45, Section 9, that have been incurred in any period for which the costs are payable to them. And then just some further consequences, really, sort of moving forward within the fixed cost regime. A defendant's costs in cases where a claimant accepts a Part 36 offer outside the relevant period are the fixed costs in CPR Practice Direction 45, any applicable additional fixed costs incurred in any period for which costs are payable to them, and less the fixed costs to which the claimant is entitled under CPR 36.23 subsection 3. So do keep an eye on dates. If the claimant loses fixed costs for the current stage, if the relevant period and acceptance are within the same stage. So I think the overriding message to you today is keep an eye on costs at all stages. Before you take a step in the litigation, you should be thinking about the cost position and understanding what the cost position will be once you've taken that step in the litigation.
I second that, absolutely. I think one of the main things to take away from the new regime is that because we're now looking at the tables, whether that's the relatively simple fast track one or the much more detailed stage structure of the intermediate track, do keep one eye on how the position progresses, preferably before each stage ticks over, so that you know whether or not to either accept an offer late, make your own offer. Just bear that in mind as you go through the litigation. Just one more thing to juggle, unfortunately, but it's definitely something that's worth keeping under review.
Yeah, so then we think about cost consequences following judgment. So we first got the situation where the claimant meets more advantageous than the defendant's Part 36 offer. In that circumstance, the claimant will be entitled to fixed costs and the practice direction for the stage at which the relevant period has expired, entitled to any applicable additional fixed costs under CPR 45 in any costs that are payable to them, and liable to pay the defendant's fixed costs for the stage applicable at the date of judgment. So that's obviously the first scenario, but as you'll be aware, there's another scenario where the claimant obtains judgment which is at least advantageous as their offer, their own Part 36 offer. In that circumstance, the claimant will be entitled to the fixed costs under the practice direction for the stage at date of judgment, any applicable additional fixed costs under CPR 45 that are payable to them, and then 35% additional costs on the amount of fixed costs between the stage applicable when the relevant period expired and the stage applicable at the date of judgment. So there's two key scenarios to keep an eye on as far as cost consequences following judgment. C beats C and D beats D. That's how I tend to remember it anyway. Sometimes the wording is quite convoluted on that section.
Yes, key takeaway, as Dan mentions, I think, is that the distinction between this and the standard operation of the Part 36 regime, for those of you that are familiar with it, is that instead of indemnity costs, we have the 35% uplift on the difference between those two stages. So it is fitted within the fixed costs regime as opposed to having separate indemnity costs.
All right, and I think we're just handing back to Connor to deal with practical tips.
Yes, just something that springs to mind out of the last slide actually. May well be helpful to put in a precedent U, the new form, if Part 36 offers have been made on the fixed cost regime, obviously a way of setting out what those costs one argues should be. And of course, staves off any disputes at the other end as well. Just a couple of tips on this slide as to the way in which this new regime works by comparison to the old one. Many would say, I think, that the new regime removes the incentive to settle as the case gets closer to trial. I'm not entirely sure that that's right. I don't think it's removed. I think the incentive to settle perhaps has been moved, but not removed. There is, I accept, a far greater incentive now for realistic offers to be made, preferably pre-issue, and indeed, rather than at any other stage post-issue. And so do consider, if you can, making a realistic Part 36 offer early. Obviously, there can be practical challenges in doing that in terms of getting medical evidence and so on. So do bear those issues in mind. As I say, some foresight can be helpful, even if we can't make a Part 36 offer early, or as early as we otherwise would like. Do keep one beady eye on the stage of the litigation as you go through. Perhaps it can become part of the habit that when we complete a step, that we also go back and review Part 36 offers and just make sure that nothing has changed before the stage ticks over. The other option that springs to mind is, rather than necessarily using Part 36 offers, we could potentially use time bomb Calderbank offers, so time-limited Calderbank offers, which then give us the scope to agree whatever it is that we want to agree, including provisions on costs particularly. And the benefit of doing that, of course, is that now we have a regime in which costs can be incurred even if the listing is vacated up to several days before the hearing, or if settlement is made at that stage. It means that by using a Calderbank offer, we can be quite specific as to what those costs might be, and that's something that you may well liaise with counsel about. Those who were here last week will know that exceptional circumstances, which used to be under CPR 45.29J, may not apply to accepted Part 36 offers. The case in which I was involved with some more senior in chambers was a case called Bosley, and it was found there, although it wasn't binding, it was found there that under the old rules, exceptional circumstances just doesn't apply to the Part 36 regime. Part 36 is a standalone regime. I've not seen anything really before or since that clarifies that issue, but something that's worth bearing in mind, although we do potentially have the unreasonable conduct provisions within the fixed cost regime. The final point to note is less advice and more of a plea, really. If Part 36 offers are on the table from either side, please do make sure that counsel knows about it at any stage in the litigation, whether that's receiving advice or going to trial. Of course, it's crucial that at trial submissions are made on those Part 36 offers, and if there's any standalone cost dispute to be had about them, it is often, in my opinion at least, I'm sure Dan will agree with me, very helpful to get counsel's 2 cents at an early stage, indeed just making sure they know about everything.
And I think, making sure it's on all the instructions that you send out, whatever stage of the litigation, whatever you're getting counsel to do, there needs to be the information about the offers in there, because the offers need to be always under review before you take any step in the litigation. I think that's the key takeaway. I think the only other thing I would add to that is on the defendant side, claims can get a lot more expensive. So sometimes look at the claimant you've got. If you've got an elderly claimant, for example, who might have a series of complications in recovering from a set of injuries that might mean that the claim gets a lot more expensive, then sometimes the amount that's claimed at the outset might actually be the cheapest time to put in a Part 36 offer and try to close down the litigation before, as I say, the injury can get a lot more complicated down the road.
Absolutely. And that then, I think, brings us to the end of what we wanted to say today. We've got a nice cover slide at the end, a little treat for you. We do have 1 or 2 questions. Yes, Shida, so sorry that there was a delay. That was completely on our end. We had some technical issues this morning, so sorry that we were running late, and you're right to tell us off.
We have finished on time.
We have finished on time. We've done quite well. The other question, Vicky, great to see you. If a Part 36 offer is made pre-litigation, settles before allocation, do fast track fixed costs apply? That's an important point to mention, Vicky, actually, and I did mean to mention that as we go through, just to clarify that small claims track cases aren't subject to Part 36 cost consequences. And the question is this: if a Part 36 offer is made pre-litigation, but a case is then issued at small claims track value and settles before allocation, do fast track fixed costs apply if that offer is then accepted? And this harks back to some of the things that we were saying last week and actually gets into some of the meat of how the new regime applies. So when we're deciding what the track should be, even if it is pre-allocation, The question becomes, what would be the normal track? And of course, a large part of that is value, but not all of it. And so if a Part 36 offer is made, and then it's not something for which the fast or intermediate track are the normal track, then no, it probably won't be fast track costs, I don't think. There's always scope for argument around the small claims track in terms of pre-allocation costs and whether or not we might be able to recover something more than the very limited costs that are set out in Part 27.14. Generally, my opinion is that you're probably limited to the small claims track fixed costs. It's a rare occasion on which we manage to escape it, especially if it's something that obviously should fall within the small claims track. If it's not obviously something that should fall within the small claims track, then there can be an argument about whether the normal track should be the fast or intermediate track. But generally the process now, in my view, is designed to be fairly watertight and to try to remove some of that satellite litigation, and so harder than it once was, and it was already quite difficult. So I think that's my view on that. I do hope that's answered your question, Vicky, but obviously you're more than welcome to reach out to us in the usual way if I've in some way missed something.
Yeah, our contact details are on the slide. We are pretty much at 15:15, so certainly thank you very much for joining us this morning. Any questions that you wish to follow up on, as I say, the emails are there, please get in touch. But other than that, thank you for joining us, especially if you've joined us for a couple of these webinars as part of the junior webinar series, and I'm sure we'll do a similar series maybe in the first quarter of next year as well.
Absolutely. Thanks so much for attending. It is great to see you all.